Today we will learn about theft and extortion. So these are the offences against property which is defined in chapter 17 of both IPC and Bharatiya न्याय Sanhita. The section for theft is 378 in IPC and 303 in Bharatiya न्याय Sanhita. So first let's see what is theft. So here I am reading from my Bare Act what is theft. So it says that whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. So theft is the dishonest intention of taking movable property out of the possession of another without consent. So let's see one by one the ingredients of theft. So here I have written all the ingredients of theft. So the first one is intending to take dishonestly. So dishonest intentions. Here the intention to take dishonestly must exist at the time of moving of the property, and the intention to cause wrongful gain to oneself or wrongful loss to another must exist. So suppose if A takes a book intending never to return, so A has a dishonest intention of never to return a book. So that's the dishonest intention. The second is any movable property. So the property must be movable. Immovable property like land cannot be stolen. So it is not a subject of theft. So stealing jewelry, money or vehicles are all subject of theft, which is movable property. So second is movable property. Third is taking out of possession. So out of the possession of any person. So the property must be in someone else's possession, not necessarily the ownership. So if a servant steals his master's cash, that means a servant is taking out of possession from the masters. So that is taking out of possession. Fourth is without the person's consent. So without consent. Now the act must occur without the consent of the person in possession. Consent obtained by fraud is not a consent. So the act must occur without the consent of the person. So things which is taken without consent is considered as theft. And the last one is intention to permanently deprive. The act must show that intent to permanently take the property. The borrowed temporary without consent is not the theft. So these are the ingredients of theft, which is very important. Now let's see the explanation of theft. So what it says is that explanation 1 says that a thing so long as it is attached to the earth, not being movable property, is not the subject of theft, but it becomes capable of being the subject of theft as soon as it is severed from the earth. So it says that if something like a tree or a crop is attached to the ground, it cannot be stolen. However, the moment it is cut or removed from the ground, like cutting tree or picking fruits, it becomes movable property and can be stolen. So it is a subject of theft. So suppose if A cuts a tree from G's land, theft happens as soon as the tree is cut, even if A has not yet moved the tree away. So that's explanation 1. Explanation 2 says that a moving affected by the same act which affects the severance may be a theft. So if someone cuts or removes something and moves it at the same time, the movement itself can amount to theft. Third explanation says that a person is said to cause a thing to move by removing an obstacle which prevented it from moving, or by separating it from any other thing as well as by actually moving it. So theft can happen not just by physically moving an object, but also by removing something that stops it from moving. So suppose if B's car is blocked by stone and A removes the stone, so the car can move. A is considered to have caused the car to move. So that is considered theft. Explanation 4 says that a person who by any means causes an animal to move is said to move that animal, and to move everything which in consequences of the motion so caused is moved by that animal. So what it says is that if a person makes an animal move and as a result the animal moves other thing like chair, table, bench, anything, it is considered that the person has moved both the animal and the things moved by that animal. So suppose if A hits G's bullock to make it work, and the bullock pulls G's cart full of goods. So A is responsible for moving both the bullock and the cart pulled by that bullock. So explanation 5 talks about the consent mentioned in this section may be express or implied and may be given either by the person in possession or by any person having for that purpose authority, either express or implied. Here, express consent means clearly stated consent, like orally or in writing, whereas implied consent is not directly stated but inferred from actions, facts, or circumstances, so which can be understood by words. So consent can be given by the person in possession of property or by someone who has the authority to give permissions. So these are the 5 explanation of theft. Now let's see the illustration. So the first illustration says that A cuts down A cuts down a tree on G's ground with the intention of dishonestly taking the tree out of G's possession without G's consent. Here, as soon as A has severed the tree in order to such taking, he has committed theft. So theft happens the moment A cuts the tree, because it becomes movable property as soon as it is severed from the earth. The second explanation is A puts a bait for dog in his pocket and thus induces G's dog to follow it. Here, if A's intentions be dishonestly to take the dog out of G's possession without G's consent, A has committed theft as soon as G's dog has begun to follow it. Here, bait means food for dog, like foods or something. Okay, so here the theft occurs as soon as the dog starts following A, because A is dishonestly moving the dog. So the other explanation, I hope you can easily understand it if you have understood this ingredients and explanation. So let's move on to punishment for theft. Punishment for theft is defined under section 303 subclause 2 of Bharatiya Nyaya Sanhita. In IPC, it is defined under section 379. It is 3 years, fine, or both. And the additional punishment in Bharatiya Nyaya Sanhita is in case of second or subsequent conviction of any person, the punishment will be rigorous imprisonment of not less than 1 year up to 5 years plus fine, provided if the value of stolen property is less than 5,000 rupees and a person is convicted for the first time, then with the return of value of property or restoration of stolen property, the punishment will be community service. So this is the additional punishment in Bharatiya Nyaya Sanhita. So extortion is defined under section 308 of Bharatiya Nyaya Sanhita, and in IPC it is defined under section 383. So it says that whoever intentionally puts any person in fear of injury to that person or to any other and thereby dishonestly induce the persons who put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security commits extortion. So what is extortion? It is the intentionally putting of any person in fear of injury to induce them to deliver property, valuable security, or anything capable of being converted into a valuable security. So the ingredients of extortion would be, so the first one will be intentionally putting a person in fear of injury. So the offender must intentionally instill fear of harm, whether physical, financial, or reputational, into the victims. So threatening to harm someone unless they pay some ransom is extortions, which come under this ingredients. So second would be intention to dishonestly induce delivery of property or valuable security. So the fear must be intended to compel the victim to deliver property or valuable security. Suppose if A blackmails B into giving him money by threatening to expose a personal secret, then that would amount to extortion, which comes under this second ingredients. Third would be property, valuable security, or anything convertible. So the delivery must involve something in value such as money, property, or legal rights. Here the property can be both movable, immovable, and other valuable security. and the fourth would be consent obtained under fear. So the victim's consent is not free but given under the influence of fear. Suppose A threatens to ruin B's reputation. So in fear of that, B hands over gold ornament in fear. So that amounts to extortion. Let's see the illustration of extortion. So it says that A threatens to publish a defamatory label concerning G unless G give him money. So he thus induced G to give him money. A has committed extortion. So here the label is a type of defamation. So if you want to see the type of defamation, I have explained it in my previous video. You can watch it. So label is a defamation in permanent form. So here A threatens to defame G. So in the fear of defaming, A has given him money. G has given him money. So in the fear of defamation, G has given A money. So that is extortion. If you see the ingredients of extortion, there is a fear of injury. So if you see the definition of injury, injury is not only the harm to body, but also it is a harm to mind, reputation and property. Second illustration is A threatens G that he will keep G's child in wrongful confinement unless G will sign and deliver to A promissory note binding G to pay certain money to A. G signs and delivers the note. A has committed extortion. So here there is a fear of injury to G's child of wrongful confinement. So this is extortion. So the other illustration is similar to this. I hope you can understand after understanding the ingredients of extortion. So now let's see some case law regarding theft and extortion. The first case is K and Mehra versus State of Rajasthan. Here the accused took an aircraft for a joyride without permission. So the court held that it amounts to theft since the intention was dishonest and it was without consent. So this is theft. And the second one is Pyare Lal Bhargav versus State of Rajasthan. So in this taking away property dishonestly without consent constitute theft. So this is a landmark case. Now in extortion, the first case is Ramesh Chandra Arora versus State. Here inducing fear of defamations to extract money is extortion. And the second case is R.S. Nayak versus A.R. Antule. So he accused demanded bribes under the threat of causing harm. So the court held that it amounted to extortion as it contained fear of injury. So these are the landmark cases. So the punishment for extortion is defined under section 308 clause 2 of Bharatiya Nyaya Sanhita, and in IPC it is defined under section 384. So it is 7 years, fine, or with both. So if you see the difference between theft and extortions, the presence of fear is absent in theft, whereas in extortions there is present of fear of injury to person or property. So the mode of possession is offender takes the property, whereas here victims deliver the property due to fear. The nature of property is limited to only movable property, whereas in extortion it is movable, immovable and other valuable security. Here the consent is no consent, without the consent of the person. Here it is under fraud or coercions or threat. So this is the difference between theft and extortion. So thank you for watching my videos, and if you like to see more videos in the coming days, then do subscribe my channel. So thank you.